Did you know the defense of insanity allows the legal system to consider mental health, ensuring justice and competence for those who are unable to understand their action? But there are several strengths of the defense of the insanity. Firstly, mentally incompetent to stand a trial. When a defendant is found mentally incompetent to stand a trial, delaying the trial ensure they are not unfairly tried while unable to understand the charges in their defense. This safeguard prevents an individual from being subjected to legal proceeding that they cannot fully comprehend, thus ensuring just process until they regain the necessary and mental capacity. Second, rehabilitation and treatment, where in the Section 10 of the Mental Health Act allow for a person to suspended to be mentally disordered to be admitted and detained in a psychiatric hospital. For some individuals may benefit more from a psychiatric treatments and rehabilitations than an incarceration. It promotes the idea of addressing the root cause of the criminal behavior. Thirdly, fairness and justice. Section 84 stated that a person with a mental disorder is not guilty if they cannot understand their action or know they are wrong. It allows for a more just outcomes in cases where the defendant's action significantly impair their ability to understand the consequence of their actions. This defense acknowledges that not all individuals who have the same capacity for the rational decision making. And finally, prevent criminal recidivisms. It can prevent the indirect discriminations when there is a rule, term, or condition that is applied generally, but which has the effect of excluding a person who has a mental illness because of the illnesses. By recognizing a several mental health issues as a legitimate defense, it prevents exclusions or unequal treatments due to the effect of the mental illnesses.
There is several limitations of the available legal provisions for this defense of insanity. In Section 84 of Penal Code, stated that the unsoundness of mind defense. The first one is terminological uncertainty. The phrase unsoundness of mind in Section 84 does not have a clear legal provisions, resulting in varying interpretation. Cost frequently depends on medical assessments, which may differ from legal criteria. This ambiguity obstructs the uniform application of the insanity defense. Second one is exclusion of missed item. Section 84 focuses only acts and does not specifically mention omissions. Although Section 32 broadens the reach to unlawful omissions, this indirect method presents interpretive difficulties in cases concerning non-actions by individuals with mental illness. The third one is limited range of defense. The insanity defense emphasizes only the cognitive inability to understand the nature or the wrongful of an act, disregarding wider emotional and psychological aspects. This strict assessment overlooks subtle mental condition like reduced responsibility or brief mental impairment. The fourth one is indefinite detention following acquittal. According to Section 347 and 348 of the Criminal Procedure Code, a defendant found not guilty due to insanity may be held indefinitely in a mental facility at the discretion of the ruler. This strict result discourages defendants from presenting the insanity defense even in invalid situations.
The fact of the case is concerning Muhammad Rozani Yahya, who was charged under Section 302 of the Penal Code for the murder of Abdul Halim Yusuf on January 25, 2018. During the prosecution case, evidence was presented indicating that the accused has mental health issue, which is schizophrenia, possibly exacerbated by substance abuse. The High Court acquitted the accused at the end of the prosecution case based on the defense of insanity under Section 85, Clause 2b of the Penal Code without calling him for defense. The acquittal was affirmed by the Court of Appeal, which relied on the defense of insanity under Section 84. The prosecution appealed, arguing that the procedural errors and misapplication of the law on insanity. The issue in the case is whether the trial judges erred in acquitting the accused at the end of the prosecution case without calling for the defense to be presented, and subsequently ruling that the defense was insanity was successfully proven.
Let us proceed with the prosecution case. Counsel, please call your witness.
My lady, I would like to call SP9 to take the forensic psychiatrist to testify.
SF9, you may proceed.
SP9, can you tell me about your evaluation of the accused?
Based on my assessment, the accused was diagnosed with schizophrenia and mild intellectual disability. However, at the time of the admission, he was in a stable condition.
Do you find any evidence to suggest that the accused was incapable of understanding the action during his incident?
No, my finding indicate that he was sound mind and understood the nature of his action.
No further questions.
SP9, you examined the accused after 9 months. Would that delay affect the results of your finding?
Delays can make it harder to assess the exact mental state at the time of the accident, but we use corroborative data to make a retrospective evaluation.
I have another question for you. Could drugs influence his mental state of the day of the incident?
Yes, methamphetamine use could potentially exacerbate his schizophrenia or induce temporary psychosis.
That's all from me. Thank you. No further questions.
My lady, I will call upon SP3, the investigation officer, to stand. SP3, what did you observe during the arrest?
The accused was hiding near a street and in his arrest, he seemed agitated but coherent.
Did you find any information during the arrest?
Yes, he led us to the weapon, a blood-stained iron rod.
Based on your experience, did his behavior indicate awareness of the crime?
Yes, his attempt to flee and his cooperation in showing us the weapon suggests awareness.
My lady, while the accused may have schizophrenia, SP9 confirmed that he was sound mind at the time of the evaluation. Further, no contrary evidence established that the accused was intoxicated to the point of insanity during the incident. His action, confronting the disease using an iron rod and not fleeing, demonstrate intentional conduct. The defense has failed to prove, on the balance of probabilities, that the accused was legally insane at the time of the crime.
My lady, the defense submits that the accused actions were driven by the intoxications or insanity, which align with under Section 84 as well as Section 85, Clause 2, Paragraph B under the Penal Code. The accused has a long history of schizophrenia and that was confirmed by the SP9, which is the medical experts. On the day of the incident, he was likely influenced by methamphetamine, which impairing his reasoning and capacity to comprehend his actions. We from the defense submit and argue that the accused could not have formed the requisite intent to commit murder, which cannot meet the criteria for insanity under the Penal Code.
According to this case, the court held that in the first instance, the High Court acquitted the accused without calling him to the defense. Later, the Court of Appeal affirmed the High Court's decision. In the present case, prosecution once again appeals to the Federal Court. After taking into consideration all the merits in the appeal, the judges unanimously warranted appellate intervention, on which the court allowed the appeal and set aside both the High Court and the Court of Appeal decisions. Additionally, the case will be remitted back to the High Court for the accused to be called upon to enter his defense on the charge preferred against him.
The court, in deciding that the High Court judge had erred in their findings, stated that the Espina medical expert opinion, which was rejected by the court on the basis of the delays in examining the accused, do not invalidate the accusations. Moreover, Espina was able to make reliable inferences based on the accused's medical records. Thus, the testimony given remains unrebutted, on which the accused was mentally stable when he committed the offence. Furthermore, the High Court, relying on the SP3 evidence by saying that the accused is insane, is insufficient and irrelevant. The present court held that SP3 is not medically qualified nor an expert in psychiatry to form an opinion on the mental state of the accused. And additionally, to earn an acquittal according to the present court, it is an honor to the defense to give evidence to show that he was incapable of knowing the nature of his act and what he was doing is contrary to the law. Thus, it is incumbent for the learned trial judge to call for the accused to enter his defense. It is a premature decision when the learned trial judge determines whether or not the accused is unsound at the very end of the stage of trial without calling the accused for the defense state.